I want to start off with what is arguably the largest single, certainly from our vantage point, case before you, if we can call it that, which is Sprint and T-Mobile. A couple of weeks ago, the Wall Street Journal reported that your staff at least has some resistance, that was the word they used, to the deal, at least without structural remedies. Is that true?
Well, I can't comment on a pending merger. But, suffice it to say, our regular process allows for the staff to communicate to the parties if there are particular issues, if there's additional data or economic support we need. And I think that was probably what was being reflected in some of the reporting that went on. But we will see. The investigation is ongoing, and we have had meetings with the parties, and it'll continue.
Yeah, how many more meetings? I know they've been quite active. And obviously, your role here is a very important one, in addition to the staff's. Have you made up your mind yet?
I have not made up my mind. Again, as I said, the investigation continues. We've requested some data from the companies that will be forthcoming. We don't have a set number of meetings or necessarily a timeline. We have a timing agreement with the parties, which they can't close the transaction sooner than a certain period of time. But as I've said, I've been very open and transparent with merging parties that we would be open to meeting as long as there's a need to meet, and we will continue to do so.
It's an interesting transaction in terms of some of the ways that they are portraying it, making in that obviously the idea of a market of 4 going to 3, some would say, well, that's a red flag from antitrust. But they're also making a very strong argument on the national security grounds for the deal, the advent of 5G. That, in fact, their combination, separately capital starved, together have the ability to really, truly bring 5G in a way that Verizon and AT&T don't. Does that resonate at all with you and the staff? Is that an important argument to be made from an antitrust point of view, or does that not really actually part of the argument that you'll be considering?
Well, sometimes those factors do figure into our consideration. So where it is important is when they raise efficiency arguments. When a merger creates efficiencies, which is actually good for the consumer, we factor those in, but there are strict guidelines about those. The efficiencies that a merger provides needs to be merger specific, meaning that you couldn't otherwise get these benefits from it. They also need to be verifiable. They can't be pies in the sky, and it has to be an important element. As far as the number of 4 to 3, obviously, the more competitors you have in any market, you might have more competition, but there is no magical number in any particular market where you don't have barriers to entry for new competitors to come in and restrain prices. That could just be one competitor. That could be fine. Obviously, in these types of industries that are regulated, you can't just go out and put up cell sites all around. So there is a barrier to entry. There's a regulatory barrier to entry. And those are factors we consider. But there is no magical number. There's no 3, 4, 5, 2. It is what the facts and the economic evidence show us.
And so what is your sense in terms of that, in terms of what will happen to pricing? This is arguably the most important bill that every American pays each month. And there are those who argue that price competition will come to an end as a result of 3 large competitors, as opposed to sort of an insurgent in the form of T-Mobile and, of course, Sprint.
So those are exactly the types of issues that we're investigating. Will there be a price effect? Will there be an increase in ultimately the price to the consumers for their cell phone bills, as well as their broadband? With the advent of the innovations that is happening with 5G and other technologies, you're going to be able to use that phone for more than just communicating with your best friend or texting. You're getting your media, you're getting video, and we want to be sure to encourage that. But ultimately, is there going to be a price effect when those two combine? There's also the other theory. When you have that combination and there's few competitors, will there be what's called coordinated effects between them? Meaning that you won't have the same incentive to compete with the other players because it is in their best interest to not compete on prices.
Yeah.
And so those are the factors, and there's strict guidelines that we follow based on a case law handed to us. And we are continuing to investigate that.
So if the staff comes to you and says, well, we think that is in fact going to be the case, that consumers conceivably will suffer as a result of this, do you just go along with it?
Well, I mean, part of my job, and one of the great privileges of being, appointed by the president, confirmed by the Senate, is to be able to make a judgment there. Now, a lot of times, we're all one team, the antitrust division, so I don't view myself as the judge sitting there between a staff and merging parties. We will make a decision collectively. My job is to make sure that the analysis is done properly, make sure that the facts are there, and if we're going to challenge a case in court, that we are looking at all the evidence properly and meets the legal guidelines. And if the case is there for us to challenge a transaction or suggest changes, we will do that.
Right. Back to this national security question, because I don't feel like you answered. Does national security play any role in the decision you're making? Because they're making this argument that, and by the way, the president certainly has said it, and many of his advisors as well, 5G is the next battlefront with China, for example. We need to be ahead in 5G. And these two companies certainly have seized on that theme, it would seem, to say you need us to be together in order to actually be able to fight that fight.
Well, that's certainly an argument the parties have made. So the issue is, do you need this merger to happen for 5G to develop? Or is this something that it would develop regardless of this merger? And that is what we call, one of the efficiency arguments that the parties would raise. So it's not so much, creating a national champion to beat out, a foreign country. That's not something that necessarily factors into our decision. But is that an efficiency that the innovation will provide for the benefit of the consumers? Because that dynamic competition that they could bring with 5G is something that certainly factors into our decision.
Now, there is also the possibility here that even if you were at the DOJ to approve this transaction, there are a number of state AGs that may still have objections. Do you work with those state AGs prior to making your decision? And what do you think is the likelihood that perhaps a number of states could get together and still try to block the transaction?
So I don't know, but we do, I don't know as far as what is the likelihood. There are independent law enforcement authorities in each of those states. There's some phenomenal antitrust lawyers and enforcers in many of these states. We work closely with them. So we have what are called confidentiality agreements and common interest agreements in place. That is routine in every merger transaction where specific states have an interest in a transaction. And this is a merger we have worked closely with the states. Ultimately, they could make a different decision. You might recall the American Express case that the Justice Department prosecuted through the District Court and the Court of Appeals was later appealed to the Supreme Court, not by the Justice Department, but by the state of Ohio and a group of other state AGs, which went up to the Supreme Court. They make independent decisions from us. And of course, the Federal Communications Commission is also reviewing this transaction because they'll have to approve the license transfers as part of that, and we all work closely together.
Right. And again, back to timing. The two parties, to the extent that they've been sharing anything, sort of seem to indicate June is sort of where they're working with as a timeline to have an understanding or actual fact as to whether the DOJ is supportive or not. Is that sort of a timeline you're working with as well here?
We work with the parties to make sure that the evidence that we need to make a decision is there, but there's no specific timeline.
Is it your sense that it could be as soon as June? I mean, I'm just kind of.
It could possibly be that. Yeah, it could possibly be. But the FCC has this 180-day shot clock that they can stop and continue.
Yes.
If you look at that timing, what has been reported is that will be sometime in the June range. But look, if the parties and we continue to work out, if there is a solution, that time could continue on because we don't have a specific deadline by which to work on.
And your meetings with them, I would assume, continue, or the prospect of further meetings with management continue?
It could. If there's a need for that, right. We're not foreclosed to not meeting with them.
Before I let you go, moving on for a moment, Judge Leon, not a name you like to hear that often.
He's a friend and is a good man.
Of course, the judge in the original AT&T Time Warner case that you brought, he's doing some strange things in CVS Aetna. What's he doing there?
Well, that's a merger, as you've
a merger that
mentioned.
is done, that has been approved, that has actually occurred and closed, and yet he continues to hear arguments, or?
Well, we challenged a portion of that merger, and we required divestiture of, I think, about 1.5 million
right.
lives to be insured that was sold to WellCare. I believe that portion of that divestiture has also been closed. The judge has a role under a law called the Tunney Act, to review our decisions to make sure that that portion of the challenge has been settled in what's called in the public interest. And there's specific guidelines. We're before the judge, and it is, it is unprecedented, but certainly the judge has a role to review our judgments.
But it is unprecedented, you just said. It's
it is
never really,
unprecedented.
nothing like this has ever happened. I mean, there is the possibility that he could try to undo the deal?
What is interesting is in preparation for this, one of my predecessors, Ann Bingaman, who was President Clinton's the head of the antitrust division. In fact, we just named an auditorium at the antitrust division after her. Yep. She was the first woman.
I saw your speech, actually.
Thank you for that. And she had argued in the Microsoft case with Judge Sporkin, who had challenged a settlement and tried to look into that. I was actually working for Judge Buckley on the Court of Appeals at the time. I had the great privilege on that particular case when it was appealed to the D.C. Circuit. And it raised certain issues about what the role and the limits of the Tunney Act are. And we will see what happens in this case. But we are complying with the judge's order. We just made some filings last week. And I think he's going to have a hearing sometime in May. And we look forward to that.
Well, Mr. Delrahim, it's always a pleasure to get some time with you. I'm sorry we don't have more, of course, to talk about some of the larger issues that you and I have discussed in the past, including right here a year ago. But we look forward to future appearances. Thank you.
Thanks so much for having me.